somebody else walking in here. We'll wait one more second. Oh, two more. Come on in.
All you had to do was stand up.
I know. And more people. It's like moths to the flame. All right. Welcome. All right. Well, we'll just get going here. Thanks for coming. I'm Dave Kallman. I'm an attorney in Lansing. It's my son, Stephen. We work together. He's an attorney also. And we homeschool, I should say Beth homeschooled the kids, both our kids all the way through. Stephen played Division I basketball and managed to graduate and get through law school. And we've been working together now, 15 years, almost 15 years. Man, that's hard to believe.
Michigan State and Cooley.
Yeah. So it's great to be here. We're here. I don't know how we got started doing this. I don't know how many years it's been now. I don't know, four. We're doing it, four times, something like that. And to just give a little legal update and things that have been happening. As you know, we have our law firm, Common Legal Group, and we have Great Lakes Justice Center, which is a nonprofit legal organization like ADF or any of the other groups out there that you hear about. And we have one case in particular Stephen's going to talk a lot about that we've just won down in Texas. And you might have seen it. It made national news on 501c3s and churches and being involved with political speech or just any kind of speech. So Stephen will get into that, but that's a pretty major win that we're very thankful to the Lord for that. And we want to talk just in general about some of the more important Supreme Court cases that have come out. There have been a few. Stephen's going to talk about a few. I'm going to spend a little bit of time on the Mahmoud case, if you're familiar with that. Really affirmed parental rights and your right to opt your children out if the kids are in public schools from training that you believe, violates your religious beliefs and that sort of thing. So we appreciate you being here. Let's start with a word of prayer and we'll get going. Lord, we thank you so much for Maranatha and for this beautiful place and friends and the ability to come back year after year and those we've lost and those who will be coming in the future. And we just pray that you will guide our time here today, put it to good use, and that it'll be encouraging for everyone here. We ask this in Christ's name. Amen. All right, well, I'll turn it over to Steve.
All right, good afternoon, everybody. So I wanted to give you a few updates on a few things, and I wanted to start with one question that we get pretty often, and so I thought it might be good to start with it, and it is the frustration of why you see the U.S. Supreme Court sometimes take cases and sometimes reject cases, and you get so upset about it, like, oh, why didn't they take that case? It was such a good case. They need to rule on this. There's this bad law, this bad precedent they need to get rid of. Why aren't they doing it? Oh, they're such squishes up there, what are they doing? They don't have any spine. And while I'm sure that is sometimes maybe part of the reason, I like to think that there's another main reason that happens. If you've ever heard the phrase, bad facts make bad law, that comes into play a lot with the U.S. Supreme Court and with a lot of courts. And basically what it means is if you have a law that in general is a good law, but then you have a fact pattern or something that occurred that's really, really bad and makes that law look bad in 1% of the time, and then the court uses those bad facts to overturn that good law, it can make bad facts make bad law. So the Supreme Court is very cognizant of that, and they don't want cases that are coming up that maybe have bad facts. They might be in total agreement with all of us on certain doctrines or precedents that need to be overturned, but some of the cases that are coming up, they're maybe not the best vehicle for them to then rule on it. And so the flip side of that is good facts make good law. And so a lot of times the court is waiting for really good facts or better facts, and that's why they're turning down cases. And a perfect example of this is a year or two ago, we had the Kennedy case that came through, which was the football coach in Texas that was praying at the 50-yard line, and there was a whole establishment clause there, and I'm not going to go into the details of that. We talked about that last year. But what it had in that case was there was this doctrine that we've wanted to get rid of for years called the Lemon test. And case after case after case, the Supreme Court would reject a case that could potentially get rid of the Lemon test. And we're like, oh, man, they're passing on the chances. Well, they took it with the Kennedy case. And that's because the Kennedy case had phenomenal facts. That Coach Kennedy had amazing attorneys, and they set up a perfect fact pattern. They did everything right at every stage of the court system. And so by the time it got to the Supreme Court, they had a fantastic fact pattern, and then they were able to use that fact pattern to overturn Lemon. And that's what happened just a couple years ago. So that's huge, because the Lemon test was something that's been the bane of our existence for decades, and that's gone, thankfully, because they had a case with good facts. So I know that happens a lot of times in the U.S. Supreme Court, where they look at a case and they're like, I'm just going to wait for better facts. And I think another part of that too is they have to get at least five of them to agree. And so a lot of times I think they look at the facts and they kind of do a sample kind of talking to each other, and if there's not 5 votes on it, then they reject it because they don't want to set bad precedent. So I want to start with that kind of preface on things, but nevertheless, the court made some very good decisions this year. And just as an aside, before I start getting into the U.S. Supreme Court, I want to talk about Michigan for just 1 second. We care a lot about homeschooling. We've done a ton of homeschool cases, and that's near and dear to our hearts. And for the past 22 to 24, I'll just say the people that were in charge of both houses in the legislature and the governor's office weren't too friendly with homeschool freedoms and rights. And so we were very concerned about that. And so one of the things that we did was we got with some other people and we formed a 501c4 organization called Protect My Children, MI, Protect My Children. And with that, we hired a guy by the name of Tom Leonard to be our activist, our lobbyist on that point. And he worked tirelessly for the past year and a half, mostly behind the scenes, because he used to be former Speaker of the House in Michigan. He knows everybody in Lansing. And he was able to work behind the scenes, and as you can see today, not a single bill ended up being passed related to homeschooling and or private schooling. Nothing happened that damaged us in that field, which is frankly basically a miracle to not have any leverage whatsoever on that subject for 2 years and then have nothing happen. So, and for full disclosure on that, Tom Leonard is running for governor, and he's hired us as his general counsel. So that's something that we're working on the side. And so full disclosure there that we're working with him and on that. So back to the U.S. Supreme Court, a couple cases I want to point out is the first one is United States v. Skermeti. And what that was the Tennessee law. If you remember, that was the law that Tennessee passed that said that banned transgender treatment only for minors. And a number of activists sued to try to stop that law based on equal protection claims and other constitutional claims, and it made it all the way to the U.S. Supreme Court. And that decision was actually written by Roberts, and it was a 7-2 decision. And that decision said, nope, that's okay, Tennessee, you can ban transgender treatments for minors. And they made a big distinction about the fact that it was only applying to minors. That was one of the key factors in it. And so they said, we're not talking about what adults can do. That's a discussion for another day. What an adult wants to do to their own body is a completely different discussion to what a 9-year-old, before they fully understand, and by the way, under the law are considered incompetent until they're 18. Totally different for a 9-year-old to be making that life-changing decision. And so the court ruled 7-2 that Tennessee's law was okay and upheld it. And so you're already starting to see, they were kind of the test case. And you're already starting to see a number of other states now modeling laws after Tennessee's, and that's making through other state legislatures, and that's great. And so that's really going to open the door to hopefully fight back on that main issue. Another big decision was the Free Speech Coalition v. Paxton. That was the Texas case regarding the age verification for pornography. And if you're not familiar, Paxton is the Attorney General of Texas, so he was the defendant who was sued in this capacity. And that decision was written by Thomas, and that was a 6-3 decision ruling that Texas was within their rights to have an 18-year-old age verification for any website that had pornographic materials on it. And I want to point out a couple key things of how they got to that conclusion. You know, we all have constitutional rights, rightly so, but they're not absolute. You know, there are certain limitations on the rights that we have, but in order for the government to overcome those rights, they have to do two main things. They have to show they have a compelling reason, which is the highest standard the court has, to show that the government has to have a really good reason to try to silence or prevent that type of speech. And second, they have to use the least restrictive way to try to silence that speech. So one example that meets that test are like threats against the president. Well, there's a compelling reason for the government to be able to punish threats against the president, even though they're words. And the court has found that the least restrictive way to stop threats against the president is criminal charges. So in this case, what they found was, yeah, sure, pornography does have free speech aspects and all those things, but Texas met that two-prong analysis. The court believed that they did have a compelling interest to have an age verification, and the least restrictive means was simply clicking yes or no of age verification was the least restrictive way for Texas to do it. So they said in that case, the government was okay. They had the authority to overcome the free speech issues there. So interesting, I just wanted to point out that little detail there because that's often left out in the media. You just see the headlines. So I wanted to kind of talk through how that worked. The next case is the Trump v. Casa case, which is technically the birthright citizenship case, but as most of us probably know it, it's the national injunction case. And that's the case that was coming up because, as we've heard in the news and every other places, that all the jokes about how, I don't know if you saw the Babylon Bee article about how Trump stepped down from office because he wanted to become an even higher authority, so he became a district court judge. And so there's a lot of jokes about that our new presidents are the 600 and some district court judges across the country. And so one of the things that a lot of those district court judges were doing is they were issuing nationwide injunctions. So even though you'd have John Smith versus the government, and those were the only two parties involved, the court would issue an order saying, this applies to everyone in America. And up until about 60, 70 years ago, that was basically unheard of because there's a long-standing precedent in American law that courts only have authority over the parties that are in front of them. And so if you're not a party in front of the court can't order you to do anything. And so it was really counter to a lot of our, hundreds of years of jurisprudence for these courts to say, yeah, everybody else in America, you're subject to our order too, even though you're not in front of us. And so this made it all the way to the U.S. Supreme Court, and Barrett is the one that wrote the decision. It was 6-3, and she wrote a phenomenal opinion. I've read it numerous times. It is just a phenomenal opinion. And she goes through and basically lays out how district courts just do not have that authority. They do not have the authority to enjoin the entire federal government against everyone in America all at once just because one district judge in San Francisco says so. And so that is really putting the kibosh to it. Now, the part I want to talk to you about is maybe the part that they didn't maybe emphasize in the media, and that is the loophole that they left in that case. And that is, I'm sure all of you have heard of class actions. Class actions are the one type of case where you can have non-parties be bound. And you've heard of different, a product injures a class of people, and so they do a class action. And just because every single person who was injured by Roundup, let's say, is not a party to the case, they're still allowed to go forward and represent all of them all at once. So that is the one exception to this party rule. And so that's what they talked about in CASA, saying you can't just do it in general, but if you follow all the rules for class actions, then you can. So what a lot of us are concerned about is that all these district judges are just going to kind of wink, wink, nudge, nudge, and say, oh yeah, class action, you're good, and then do the exact same thing. So there may end up being a second round to this fight of national injunctions coming down the pike, but we'll have to see. We'll have to see how the court handles it, because normally to become a class action is quite a high bar. You have to meet all sorts of thresholds and proofs and things like that, but we'll see how the district judges handle it moving forward. Nevertheless, the issue that was in front of them, enormous win to strike down and say that all district courts do not have that authority to do nationwide injunctions. The final case that I want to talk to you guys about is our case. And that is not in front of the U.S. Supreme Court, but I want to give you an update on it. And that is the NRB v. IRS case. And that is a case that we brought in Texas. And we actually brought it while Biden was still president, not knowing how the election was going to go. But we brought it last year while Biden was there. And for those of you who are not aware, maybe some of you have heard of the Johnson Amendment. And basically what the Johnson Amendment is it was put in place by Lyndon Johnson because he was upset about pastors speaking out against him. And what it said was that all churches, all 501c3 nonprofits, you can no longer speak on politics. Now there's some very minor exceptions, but in general, you can't speak in the pulpit about politics, you can't endorse candidates, you can't you are silenced on these things. And if you do start talking about candidates and you do start talking about politics, the IRS is going to come in and yank their tax status. And then everyone that donates to those churches no longer gets a write-off. The church no longer gets the tax breaks that a 501c3 would get, and it was a very heavy hammer. And so what that did was it chilled the speech of many churches where they didn't even want to get close to the line of talking about politics, so they avoided it like the third rail, and they didn't talk about politics at all. Well, we didn't like that, and so we thought, let's challenge it. The court's in a great spot. The Supreme Court's in a great spot right now. We've got good justices on there. Let's see if we can make some good facts and maybe get a case up there. And so we started looking around, and we noticed that there are lots of other 501c3s that do lots of political activity and suffer no consequences whatsoever. Did you know that a lot of newspapers are actually formed as 501c3s? But newspapers certainly endorse candidates. They certainly write about politics. Did you know that a lot of VA organizations are formed as 501c3s? And they endorse candidates. So we found a whole number of examples of certain types of 501c3 organizations that suffered no consequences whatsoever for engaging in political activity. And so we thought, we've got our equal protection claim. The government is treating some people differently than others. And so we brought this case in Texas. So after we brought it, there were some initial motions and filings that were done, but then a few months after we brought it, the election occurred, Trump won, Bondi was put in charge of the DOJ, and so we started having discussions with the IRS about what could we do to resolve this? Is there any interest in resolving this case? And so we did come to a settlement with the IRS, and what it says is that the IRS is agreeing that they will no longer enforce the Johnson Amendment against any churches, and as a binding consent judgment. And what that means is it's not just taking their word for it, it would be a court order, a consent judgment. They're agreeing to have a court judgment against them saying they can't do this anymore. And so we were obviously thrilled with them doing that, and so we wrote up a whole consent judgment motion and all the paperwork that goes with that, and we sent that into them, and we made our tweaks and everything, and we filed it with the court. And then as soon as we filed it, a few organizations out there, the Americans United Against Church and State, for the separation of church and state, and other atheist organizations, as soon as they heard, oh my goodness, they reached a settlement, they have filed motions for what's called intervening, which means they're trying to become a party in the case. Remember I talked earlier about how the court can only cover parties in the case, and they're trying to become a party so they can appeal and they can have all the rights that a party would have. And so they have filed a motion to intervene. And then on top of that, a whole bunch of organizations that opposed the settlement that we're doing have now filed what are called amicus briefs, and that's where they don't become a party of the case, but they can still file paperwork and a brief with the court outlining their position, and the court can consider it. And so we've now had numerous amicus briefs filed both in support of us and against us. We have a pending motion from this Americans United group to intervene to try to become a party. And in all this time, the judge still hasn't signed the order. So even though we have agreed with the IRS, we don't have our judgment yet. And so we don't know exactly how the judge is going to go on this. We're assuming he's going to be friendly and sign it, but we don't know. He's the judge. And he may just be letting everyone have their say, and then he's going to make his ruling. But we'll see. So there's some pending deadlines coming up. I believe the next response deadline is August 15th, so right around the corner. And we'll be filing more paperwork there. But hopefully the judge will approve our settlement, make it binding on the IRS. And, but worst case scenario, it goes up on appeal, and then we can just make precedent on appeal and have it go to the Supreme Court. So as far as we're concerned, it's kind of a win-win. If the judge signs a settlement, great, we win. If we go up to the Supreme Court, we think we've got a great shot at winning too. So we're really excited about that, and that's been a fun case to work on. So with that, I'm going to hand it over to my dad, and he's got a couple cases too.
Thanks, Steve. Just a couple of things on that Texas case. Mike Ferris, who some of you may know, he started Homeschool Legal Defense Association. He ran ADF, Alliance Defending Freedom, for 5 years. He retired from there a year or two back and went to work for the NRB, the National Religious Broadcasters, that's the NRB, who are the plaintiffs in the case. And he's the one that came up with the idea and recruited us to work with him on it. So it's been a real honor for us to be a part of that. And as I said, when this was all signed and we submitted it to the judge, apparently the IRS put out a press release and stuff trying to get ahead of it because we didn't want to say anything. We wanted this to go through, have the judge sign it, be quiet about it, until it was done. Well, then it hit the national news, and it was all over the place. And the next thing you know, we've got Americans United and all these different groups trying to intervene now. So we'll see what happens on it. But I've known Mike for, oh my goodness, I'm going to date myself here, probably 45 years. I was in law school when I met him. And he was actually the attorney at that time for Concerned Women for America. I'm sure many of you know CWA. Beverly LaHaye started it. And so I met him when he was general counsel for them. So and again, we're not telling, look, a lot of churches, I doubt these days many pastors are going to get up in the pulpit and endorse a candidate. I mean, it's up to them. But there's lots of things. What about the abortion issue? What about all these different issues that are out there? And churches have been reticent to get involved, let petitions be put around to even talk about it or lobby on it. Now they're free to do it on all these other issues. It's not just about endorsing candidates. And so what it does, though, is it gives the freedom to the churches to do it however they deem best for their church. And that's the way it should be. It's like 5 years ago when we filed the lawsuit because Governor Whitmer shut down churches in Michigan, if you remember that. And she shut them all down because of COVID. And we filed suit in federal court because our position is, I don't care what's going on. I don't care if an atomic bomb has gone off. Government can't shut down churches, period. They cannot be given that power. And so we filed suit in federal court, and the next day, Governor Whitmer reversed her order and allowed churches to be open. Now, once that happened, were there a lot of churches that stayed closed during COVID? Yes, but you see the difference? It's their choice at that point. And if they live stream and they do things, it's the church's decision, not the government's. So that's a key principle that we operate on all the time. One other thing I want to mention just on the Kennedy case that Steve had mentioned. We did an amicus brief, and Professor William Wagner with Salt Lake Global Great Lakes Justice Center, and we all worked on the brief where we urged the court to get rid of this lemon test that was done, that was in place for decades and really hurt religious organizations. We were the only brief. There were dozens of amicus briefs filed with the Supreme Court in this case. Our brief was the only one that urged the court to get rid of the lemon test. We were the only ones arguing that, and the court did it in their decision. In fact, kind of quoted from some of our brief, it was kind of an amazing thing to see happen. So that's the kind of things that we just feel just so fortunate and honored to even be a small part of, and to have a part of those kinds of cases and to be involved has just been such a pleasure. And especially for me to be able to work with this guy doing it, and to see your son doing it. He's third generation now. My dad was an attorney and a judge, and we worked together after he retired from the bench. And so you've probably seen some little guys running around here that may hopefully be the fourth generation coming along, but we'll see. One other thing before I talk about the Mahmoud case, which is what I'm going to take a few minutes to talk about, because we want to leave time for question and answer. I know last year that seemed to be the most productive. I just want you to know we do not follow the Ron Zappia rule of speaking at Maranatha. If you will notice, we have shorts on. So just if you see them around, just tell them that, we're standing up. We're speaking truth to power, okay? We're just like, don't get me going. I'll tell you, though, this has been a really good week for fodder for the song tomorrow. I got to tell you. There's been a lot of good stuff. And you can rest assured the flamingo shorts are in there. All right, the Mahmoud case, which is another one the Supreme Court just ruled on the end of June. Mahmoud v. Taylor. This case was just an amazing decision from the U.S. Supreme Court, and it dealt with the rights of parents to direct the upbringing, education, care for their own children. Because this has been a fight for a long time. Stephen wasn't born yet, maybe. But heard an educator one time say, parents procreate, we educate. Now, isn't that an amazing point of view on so many different levels? You know, it tells you a lot about not all educators, and I don't mean to paint a broad brush. There's lots of really solid, committed people that work in our public schools and Christian folks. But more and more and more, there's a lot of people who aren't. And it's the vast majority are not like that. And that really is their mindset, is they control what your kids and grandkids are learning, not the parents. And this Mahmoud case really, set them back big time in that belief and that practice. What it was it involved a group of parents in Maryland who they objected to a number of books, most of them dealing with LGBTQ type of materials. And it wasn't even just that the books were made available to the children, but the books were actively read to, talked about, and used to educate the children. So it was more than just making some book available that a kid, if he wanted to or she wanted to, could pull off the shelf and read. That's one level. But this case went beyond that. And Maryland has a law, just like most states in our country have a law, that allows parents to opt out on sex education and other objectionable materials in their public schools. And so the parents had gotten together, gone to the school board, and objected, said, we want our kids opted out. And initially the school said, yes, we'll do that. And they opted them out, and they took them out. But after about 6 months, a year, there were so many parents taking their kids out of the classes that the school reversed course and said, no, now we're going to make you do it anyway. And so they would not allow the opt-out anymore. So the parents sued under this. And the school basically said, as I said, too many parents are opting out, so it's just unwieldy. We can't have half the class getting up and walking out before a discussion is done. Secondly, they said these LGBT books are exempt because they're being taught as literature. And so it's not imposing any viewpoint or anything like that. That was their second argument. And their third argument was diversity, equity, inclusion. We're just trying to make everybody feel included and safe. Unless, of course, you happen to be a Christian child in the thing, then we don't care about you feeling included or safe. We'll mock you and make fun of your beliefs, but anybody else, we're going to try to make you feel more inclusive or more included. And that was the main reasons that the school district said, we should not be forced to opt these children out. The court basically said 4 things. And it was Justice Alito, and I don't usually, a lot of times people, I don't want to read some court decision, it's so boring. You really should read this decision, Mahmoud v. Taylor by Alito. It's easy to read, it's not necessarily all in legalese, and it's just an amazing stand in favor of parental rights. But the first argument he knocked down was the state, the public school claiming, well, this isn't coercion, this isn't forcing kids to do anything, this is just exposure of the children to these sorts of things. And Justice Alito just tore that apart. In fact, they gave a few examples. I think one of the examples was a teacher, when a child objected and said something opposing, the viewpoint of the book, the teacher reprimanded them and told them that they were wrong and that they needed to be more open-minded and did this in front of the whole student class. So Justice Alito said, that's not exposure, that's coercion. And that's what they're doing. Second argument that Alito talked about was the argument from the school. In fact, the school made this argument also. Well, if parents don't like it, just pull your kids out of our school. I thought, be careful what you wish for, buddy. I mean, that's a pretty dangerous thing to say, but that's what they said. And Justice Jackson, who's on the Supreme Court, actually made this argument from the bench during oral arguments. Well, just tell those parents to pull their kids out if they don't like it, kind of a thing. Well, again, Alito tears that apart, and he points out how so many families these days are single-parent families. The one parent's working. They don't have options to homeschool or pay for a private school. They don't have any other choice. And so they can't pull their child out for economic or other reasons. So he threw that one away, said that doesn't work either. Then another argument that he made, or that the state made, is, again, that the kids were not being taught out of the books, and Alito was able to prove through the evidence in the case that that was not the case. And then he used a lot of, that's what's interesting, if you read the decision, they actually post excerpts from the books and covers from the books and the content. I mean, it's right there in the opinion, you can see it. It's disgusting stuff. And this is what they were just saying, oh, we're just being inclusive and opening up the children's minds to it. No, they're brainwashing these kids into thinking at 5 years old and 6 years old that the boy can be a girl and that it's okay for boys to be with boys and that sort of thing. That is hardly just neutral as they try to portray it. And one of the books that he talked about was Uncle Bobby's Wedding. So, I mean, just the title of it, and you can get an idea of what was going on with that book. And so Alito was real clear. I just want to quote a couple of things here that he said. He said, we disagree with the dissent's, he's talking about Jackson's dissent, deliberately blinkered view that these storybooks and related instruction merely expose students to the message that LGBTQ people exist and teaches them to treat others with kindness. In making this argument, the dissent ignores what anyone who reads these books can readily see. It ignores the messages that the authors plainly intended to convey, and what is perhaps more telling, it ignores the board's stated reasons for inserting these books into the curriculum with the instruction that it gave to the teachers. Only by airbrushing the record can the dissent claim that the books and instruction are only about exposure and kindness. I mean, he's real methodical in the opinion, going through, why this is indoctrination and this is brainwashing little kids. So it's really just a great decision. So to bootstrap from that as a practical thing, what can you do? As I said, most states have opt-out provisions. Michigan has one, and it's dealing with sex education. Now, you might say, how does LGBTQ or things like that fall under sex education? Well, here's one of those be careful what you wish for kind of moments again. Our Michigan Supreme Court ruled a couple years ago in a case we argued in the Supreme Court and lost. They argued our civil rights law defining the word sex, that it included things like sexual orientation, gender identity, things like that. So they redefined the word. I mean, the word had always meant biological sex in the 50 years that the law was in place. They made up a new, definition and changed the application of the law. Well, like any good lawyer, we sat and looked at that and said, okay, how can we use this against them? If they're going to do this. And it popped in my head. I'm sure the Lord was probably knocking me big time in the head. We have opt-out provisions in Michigan for sex education. Well, the word sex now doesn't mean the birds and the bees and male and female. It means sexual orientation, gender identity, LGBT, all this stuff. So we're going to argue that, that's what it means now. And now we have Mahmoud backing it up with an opt-out provision. The Supreme Court has said parents have the right to opt out. So we have prepared a parental education opt-out form. And I brought a couple. What I'm going to do is I'll probably go and have them make some copies, and we'll put them back out here on the table or something if you want to pick them up tomorrow. We'll have them out here for you. But I know not everybody's from Michigan, so we have one that's more generic if you're not from Michigan. But they both essentially do the same thing. Michigan's form includes a few more things, like up at the top here, there's a state statute which says that, I'll just read it, it's real quick. It's the natural fundamental right of parents to determine and direct the care, teaching, and education of their children, Public schools of this state serve the needs of pupils by cooperating with the pupils' parents to develop the students' intellectual capabilities and skills in a safe and positive environment. So some of that language is really important. Fundamental right, natural right of parents. And so now, combined with Mahmoud and the sex opt-out statutes that we have, we think this language in this statute that's in part of the education code now has some teeth. And it's kind of fun to use this because I helped write that law 30 years ago in 1995. That's when it got passed. And it just means I'm getting old, folks. But and actually, Mike Ferris had a hand in it. We sent it to him to look at, and some others. But we had some good legislators in Michigan back then, and we got that language added to the law. So you have rights as parents, and if you're a grandparent and you have kids that are in the public schools, and your kids and their kids are in situations where they don't have a choice, you have options, folks. You can do this opt-out, and believe me, if they don't follow it, call us because we will sue. In Christian love, okay. Okay. But we will sue because they're violating the law, they're violating the parents' rights, they're violating the students' rights if they don't let you opt out of all this objectionable, trashy stuff, okay? I mean, there's no other way to put it. You know, sometimes we get some pretty crazy calls, you know, and Steve was talking about the one case with pornography, the right to, that, you know, states can restrict that to children, you know, it's for their health, safety, and welfare, right? We actually got a call from a guy, I won't say who it is, wanted us to represent him because his constitutional rights were being violated because he was a strong conservative, right-wing Republican, and he could not access porn anymore on the internet because of these laws that restricted and had, and he objected to having, you know, prove he was 18. Can you believe such a crazy call? I didn't even call him back. I mean, it just shows, though, that as Stephen said, there's a wide range of opinion on a lot of these things out there. But we are seeing a lot of cases more and more and more moving toward protecting First Amendment rights, parental rights, and all these things. So it's been a good year, and we're thankful for a lot of these decisions that came down. So we've gone about 40, 45 minutes, longer than we expected, but why don't we do a question and answer, and we're happy to try to answer. Let me say this, if anybody has something that's more specific, you know, or, you know, directed for you, like it's a situation you're in, feel free to come up afterwards and talk with us. You know, we want to try to make this more general, something that might be applicable to everybody, but we're happy to stay as long as necessary to answer questions. Well, a lot of states have done it, not in Michigan because we have one-party rule right now, and the party ruling will never do it. Not really.
Age verification, how difficult is it to verify age? Is that part of just press a button so you can lie?
Yeah.
Essentially.
My understanding is you just have to hit yes. So,
Yeah,
Is there any hope that, I mean, that's almost,
kind of meaningless in a way.
yep. I would say it's the first step. Yeah. Right there.
had listened to Supreme Court Justice Jackson's confirmation hearings, and in most of her responses, they were not way to the left. But now that she's on the court, it seems like the corner phrase she just whacked out.
Yeah. Yeah. It's funny. For years, we've always joked that Sotomayor is, you know, as far left as you could possibly go. Her heels are at the cliff. And yet somehow Jackson has gone further. And so one interesting thing on that is if you ever, you know, say you're having trouble going to bed at night, just pull out a Supreme Court opinion and start reading it. But no, I'm kidding. I'm kidding. But that decision, that CASA decision that Barrett wrote, I have never seen a justice go after a colleague and how much Barrett went after Jackson more than I have seen in that opinion. It was one of the most fire and brimstone, knockdown, or in your face thing I've ever seen. And so that makes me think there's a lot of discord. You know, I would love to be a fly in the wall in their chambers meetings where the 9 of them get together and talk about cases. But what's funny to me and what is interesting about that is there have been points where even Kagan has really ripped on Jackson. And if there is one of the 3 liberals that I have the most respect for, it is Kagan. On the really big political cases, the ones that make all the news, she usually falls in party line in sides of the liberals. But there have been a lot of cases that maybe aren't quite as public, and her opinions have actually been pretty good. They've been follow rule of law, and they've gotten a lot of conservative justices to sign on to her opinions. So if there's any one justice that I hope we sometimes get, it's her. But what's interesting about that is she is publicly in opinions also ripping Jackson. So I've never seen anything like it. I don't know if it'll ever rise to the level of impeachment of someone like Jackson, but obviously that'd be very difficult to do. But at the very least, what I can hope is that she's not making any friends on the court, and she's just alienating herself, which would make it even harder for her to get other people to sign on to her beliefs. So that's my hope on how she's doing it.
Remember, she's the one, when asked the question, can you define a woman, said, what? I don't know. I'm not a biologist. I mean, that told me everything you need to know about her right off the bat. Anybody else? Yes.
As a resident of a city or a village, do we have a say of our library that promotes equity?
Yeah. The question is, as a city or a township or a county resident, do you have the right to object to or have a say in books that are in your local libraries? And the answer is yes. All these libraries have a board, and they have public meetings, and you can have parents, and you can come and you can petition and ask them to do all kinds of things, remove books and things like that. And then if they refuse, and it's something really pornographic or something really bad, then you can sue over that sort of thing. Now, there's a distinction, remember, between city, local libraries and the school libraries. Those are 2 different things. You know, the public school library is run by the public school. There's not a separate board over that other than the school board. You know, but you could do the same thing. If your school library was having objectionable materials in, then you could petition, get a group of parents together, go to the school board meeting and do the same thing.
Only point on that I would caution is that there have been a number of cases across the country of people litigating on that issue, and I have yet to see one be successful. It's a very high bar, and the reason for that is in the Mahmoud case, they were using it as those books as part of the curriculum and grading off it, and as you heard, the coercion that was involved. That's an entirely world different than just being on the shelf at the library that adults can access, and that's what the courts have been making a distinction on. So you can bring litigation, but that's a really big uphill battle.
And I have spoke with a number of folks around the state on these issues, and one of the best ways to deal with it is these library boards, believe it or not, are appointed and elected by various commissions or elected. You should find out how they're put in the board and then run people. They're not that, but there's usually only 5 people on these boards. All you need to do is get 3 people on the board, and then you can take out whatever you want and do whatever you want to do. And that is a lot better way to handle it than necessarily filing a lawsuit. I saw another hand. Yeah, Dave.
Can you say anything about how you decide to support somebody for governor?
Mm-hmm.
'Cause I know criminals can have lawyers too.
So how do you, and maybe more in general, how do you make a choice to what type of candidate to, you know, support and that sort of thing? Yeah, I mean, look, this is us. I mean, we're not speaking on behalf of Maranatha or anything, but in general, I think you want to look at, you know, what are their core beliefs? What are their, what's their faith background? That sort of thing. You know, look, when you're voting for a person for a secular office, you're not voting for your local pastor. You know, you're not voting for the deacons on your church board, you know, other elders or anything like that. You know, you're voting for people that have to deal with everybody in the community And what you're looking for, now it's great if you have a Christian running, or if you have somebody and find out what church they go to or what their beliefs are, then obviously that helps you in making that choice. But you're not always going to have somebody of like mind faith-wise, running for offices. And so there you need to look at what are their positions. There's a lot of times that there are people who agree with us, like, for example, on pro-life issues, and agree with us on smaller government and cutting taxes and things like that. But maybe they're Muslim, or maybe they're, pick your other, denomination or type of religious belief. But does that mean you're not going to support a person like that, because they'll act appropriately on those kinds of issues? See, that's what you have to weigh, is look at those sorts of things. And then secondarily to that, I would say you have to look at, sometimes it's the lesser of two evils, and maybe you've got two bad candidates, okay? But let me use New York City right now and Minneapolis as an example. You've got outright Marxist communists running and have won, their Democrat primaries to be the mayors of those towns. Well, other people running in those offices aren't necessarily Mother Teresa, or necessarily somebody that you probably agree with on 80% of what they agree on, but they're not outright Marxist communists, okay? And so in that sort of situation, would I vote for the lesser of two evils? Of course I would, I'd hold my nose and do it.
So we get this question a lot, how do you pick? What if you don't like both candidates? And there was one study, and I'll give credit to my wife, Paige, because she turned me onto this avenue, and then I went down it. All of us are called to be salt and light. And I want to focus on salt for a moment. What is the primary purpose of salt? It is to slow decay. It is to preserve. It is to stop something from dying. It is to stop meat from rotting. That's its major purpose. So when we're called to be salt in our communities, our societies, I would say it is to slow the decay. That is one of our primary things that we're called to do. So when you're evaluating two candidates, the question I ask in my mind now is, which of these two candidates do I think would slow the decay the most? And which one do I think would help preserve society the most? And that's the rubric that I use, and then I vote accordingly. So that mindset really helped me as I was thinking about it, that it's hard when you have two candidates and you don't like either of them, But if you can come up with one where you're like, I don't like this one, but I really think on this issue, I know they would be good on, then maybe they would slow the decay more than the other. And so I vote accordingly. Yeah.
In that same vein, I've asked this before. Do you know if there are any resources available to choose whether or not to re-elect or elect judges?
Yeah, that's a tough one. So obviously at the federal level, judges are appointed in there for life, so there's no issue there at the federal level. For the state level, judges are elected all the way from trial courts up to our Supreme Court. We work a lot with James Muffett, who's with Citizens for Traditional Values, and I know he has been working on for a while, although I don't think it's up and running yet, a program to do exactly that. CTV already does voter guides for the legislators, where they send out questionnaires and they find out where all the candidates are, and then they put out voter guides so people can know where every candidate stands on all the issues. And they've talked about doing, and I know they're working on doing something very similar for judges. That would be immensely helpful because short of that, there isn't a great resource. We certainly try as much as we can to put out there who we're supporting, especially if it's a Michigan Supreme Court position, because we get that question a lot, and Court of Appeals too. But unfortunately, there isn't a great solution. Yeah.
Well, and one of the things, like we get calls every election cycle. I probably talk to 25, 40 people. I don't know how many people we talk to, and I know you get calls. Well, who are you voting for, Judge? In this, what about district judge? What about circuit judge? And I tell them, here's who I'm voting for, So what I say that because you should find out, there's Christian lawyers in your area. There are judges who are respected and conservative. Now, judges aren't going to necessarily tell you, who they would vote for. But there are ways they can let you know. You know, like I mentioned, my dad was a judge for 30 years, and he would come up, and people would come up to him all the time and say, Judge Coleman, are you pro-life? And he'd say, well, you know, I might get a case in front of me that deals with right-to-life issues, and I don't want to have to be taken off the case or recused. So I'm not going to say one way or the other, but you know, my wife's standing right over there. Why don't you go ask her what she thinks about the right-to-life issue? So there are ways, you know, that you can do that sort of thing. So, but talk to people in your area who are in the know, you know, to find out on those local judge races. Yeah.
So I think it was top 3 in the state of Michigan.
Right, on abortion. Right.
And also to have an abortion without telling their parents, without notifying.
Right.
Do you see that Tennessee ruling having some bearing on that? Because it's that, I mean, I'm a medical professional.
Mm-hmm.
I treat a kid who has a broken arm without their parents' consent.
Mm-hmm.
That's illegal.
Right. I think it might, the Mahmoud case might actually help with that, and there are other cases. We have said since that went into effect, if there's a parent out there and their child has an abortion and it's done through the school or whatever without your consent or knowledge, and you want to sue, come to us, we will file a lawsuit like that, because that's probably the only way to undo that, other than to do another constitutional amendment to try to undo that one, which is a very tough road to go down. But you could bring, because I think that is undermining parental authority and the rights of parents to their children and care and upbringing and all that sort of thing. So I think that would be a great lawsuit. Now, in Michigan, do I think a lawsuit like that would win with our Supreme Court? No, I don't. I think it would lose in a heartbeat. But we would bring a lawsuit like that in federal court. We would stay out of the Michigan courts for that reason. So there are ways. So if anybody ever hears about something like that, or whether they should call us, you know, because we would take a case like that in a heartbeat.
How much effect has Roe v. Wade, overturning Roe v. Wade had? Because it seems as if that even though it was overturned, they're all doing their own thing still.
Mm-hmm. Well, that's true. A lot, but see, we're seeing it from the perspective of like Michigan, which doubled down and made abortion even more onerous, you know, and everything. And there are, you know, California, New York states, more liberal states, still have abortion on demand at any time right up to the moment of birth. I mean, it's ridiculous. But you're overlooking the 2/3 of the states that don't have those laws and that don't have these things going on. It's a state by state thing. And unfortunately, we're in a state here in Michigan where it's not been good.
To do that, one of the main points that Alito made in the Dobbs decision was that abortion is such a politically contentious and emotional, and rightly so, issue that that issue should never be decided by 9 people wearing robes. And so one of his main reasons in Dobbs was that this needs to be sent back to the states, and it needs to be sent back to the people to vote through their representatives on it. And just like free speech, if you get free speech, there's going to be people out there saying stuff you don't like, but there's also going to be people out there saying stuff you do like. Same thing's happening here. We're having states that some are doing things that we don't like, and some are doing things that we do like. But that's part of the political process, where each state can be a laboratory of, you know, their own legislation, even if we vehemently disagree with it. So our role has now switched from trying to convince 9 judges to trying to convince our fellow man of why this is a good or bad thing. Yeah.
Michigan, it always seems like there's questions about their voting and that your vote might be changed or twisted, and people have these testimonies and nothing seems to happen about the voting. Is there any lawsuits against how they do this, and is it going forward with exposing something is wrong or not wrong? Are they afraid to do it because they're afraid of being sued by Dominion or whatever it is?
There are no, at least that I'm aware of, there are no currently pending lawsuits regarding any voting issues in Michigan. A lot of that is because the window of time that those lawsuits can operate is quite small. And so, you know, if someone is saying, oh, there's voter fraud happening in Detroit, that's usually happening during the, you know, early voting or all the mail-in voting, so that narrow window of time. And then we have the certification date where they certify the vote. And a lot of those cases have to be decided before that certification date, or else the court says, it's moot, the election's over, we can't hear it. So the courts have not been a great forum to address this issue. It really needs to be done legislatively. And unfortunately, the people in charge haven't been willing to do that. So that's why 2026 is so important, because in 2024, none of the Michigan senators were up. But in 2026, all of them are up. And so there's a real chance here to change the governor, to change the Senate, and to change the House. And that's the best shot we're going to have since 2020 to really look at and address those issues. Well, it's just about 2:30. Maybe one more question if there is one. All right. Well, we'll be up here if anyone wants to come say hi. Thank you so much for coming. We really appreciate it.
Thank you.